Please be seated. We will swear.
The ICC judges have ordered Kenya to compel witnesses who have already expressed their unwillingness to testify against Deputy President William Ruto and radio journalist Joshua Sang to do so. And it read in part, the chamber found that the government of Kenya has an obligation to cooperate fully with the court by serving the subpoenas to the witnesses and by assisting in compelling their attendance before the chamber by the use of compulsory measures as necessary. But the Attorney General maintains a hard stance that no witness can have their hand forced into giving testimony to the court.
Any country in the world can write us a letter and say, we require Mr. Odede. That treaty would not be worth the piece of paper it is written on. Why? Because the rights of the citizen of the Republic of Kenya are so fundamental that they would trump in a contestation.
Professor Githu Muigai, while addressing the trial chamber judges in February this year, argued that unless a witness is already within the court's jurisdiction, they cannot be compelled to testify.
If the witness is within the territory of the Republic of Kenya, the answer is no. That witness is not compellable by you and is not compellable by us.
There cannot be a threat that if witness X does not accede to the requirement or the order of the court, that the witness can be incarcerated, deprived of their liberty, bundled into a van and taken to a location.
As you do know, sir, the witnesses before this court are not known by the Kenya government at all. We cannot put a name to any person. We have never been part of the process of discovery. To the extent that the Kenya government is aware of any witness, it's the witnesses that have already testified, and most of them have done so in camera in this chamber. How did they arrive at The Hague? We don't know.
The submissions by Professor Muigai notwithstanding, the trial judges went ahead to grant Bensouda's request to have the 8 witnesses compelled to give testimony to the court. But has this changed the position of the Kenyan government that this is a near impossible request? The Attorney General has on previous occasions emphasized the sovereignty of Kenya as a state, begging the question, can the Hague court take any action at all if the Kenyan government does not honor this request? However, should Kenya feel compelled to produce the said witnesses, the process would have to be given the green light by the Director of Public Prosecutions, Keriako Tobiko, to kickstart a court process on enforceability of the subpoenas, a process that would remain contestable on grounds of unconstitutionality. Jacky Maribe, Citizen Weekend.